Prescription General Provisions Art 1106. By prescription, one acquires ownership and other real rights through the lapse of time in the manner and under the conditions laid down by law. In the same way, rights and conditions are lost by prescription. Prescription in acquisition of a right by a lapse of time. A limitation which refers to the time within which an action must be brought after the right of action has accrued, a statute of repose whose object is to suppress fraudulent and stale claims from springing up at great distances of time. Negligence is basis of prescription. Both kinds of prescription are essentially based on negligence of the owner of the right. Retroactive. Acquisition of rights through prescription is retroactive. One is deemed to have acquired the right at the moment the prescription began to run. Once the period is completed, prescription v. Laches. Laches is based on grounds of public policy which requires, for the peace of society, the discouragement of stale claims. Prescription is based on fact of delay, on a fixed time, on a question of time, is based on statutory law. Laches is based on effect of delay, is not time-bound, is a question of equity in permitting the enforcement of a claim, is not statutory, and is based on equity. Requisites of laches: conduct on the part of defendant, which gives rise to a claim. Delay in asserting complainant's rights, the complainant having the knowledge and opportunity to file suit. Lack of knowledge or notice of the part of the defendant that the complainant would assert a right, injury or prejudice to the defendant in the event relief is accorded to the complainant. Types of prescription: acquisitive, acquisition of a right; adverse possession, usurpation. Refers to the possessor as the actor, as a claimant in possession. Vests property. Basis, assertion of the usurper of an adverse right, uncontested by the true owner of the right, and gives rise to the presumption that the latter has given up the right to the former. Effect of acquisitive prescription? Two sides. One side says the right to return the thing is extinguished upon prescription. Another, Tolentinos, says that a natural obligation to return the thing subsists, for two reasons. The law considers an obligation barred by prescription as a natural one, and the voluntary return of the thing can be considered as a renunciation of prescription. Extinctive, loss of the right, limitation of actions. Refers to the neglect of the owner, who is out of possession. Bars the right of action. Basis, probability that alleged right never existed or has already been extinguished, or if it exists, the inconvenience caused by the prescription should be borne by the negligent party. Art 1107. Persons who are capable of acquiring property or rights by the other legal modes may acquire the same by means of prescription. Minors and other incapacitated persons may acquire property or rights by prescription, either personally or through their parents, guardians or legal representatives. Capacity for prescription. General rule: capacity to acquire property or rights by other legal modes is required for prescription. Exception: minors and other incapacitated persons with discernment can acquire through prescription. But this acquisition will be voidable or annullable, and can be ratified when the minor comes of age or when the incapacitated becomes capacitated. When discernment is absent, these persons can acquire through their legal representatives. This acquisition is completely valid. Discernment requires animus rem sibi habendi, an intent to appropriate the thing as one's own, an essential element of possession. Requisites of valid acquisition: 1. Majority age. 2. Minority age or incapacitated, as long as through legal representatives. Requisites of avoidable acquisition: minority age or incapacitated without the assistance of parents, guardians, or legal representatives. If the property requires just title, the same capacity required for the possession of title is required. If by donation, capacity for donees is required. etc. In other cases where title is unnecessary, capacity for possession is required. It is an element common to all kinds of acquisitive prescription. Art 1108. Prescription, both acquisitive and extinctive, runs against 1. Minors and other incapacitated persons who have parents, guardians or other legal representatives. 2. Absentees who have administrators, either appointed by them before their disappearance, or appointed by the courts. 3. Persons living abroad, who have managers or administrators. 4. Juridical persons, except the state and its subdivisions. Persons who are disqualified from administering their property have a right to claim damages from their legal representatives whose negligence has been the cause of prescription. Art 1109. Prescription does not run between husband and wife, even though there be a separation of property agreed upon in the marriage settlements or by judicial decree. Neither does prescription run between parents and children, during the minority or insanity of the latter, and between guardian and ward during the continuance of the guardianship. Persons affected by prescription, minors and incapacitated persons who have parents, guardians, and legal representatives, absentees who have administrators appointed by them or the courts, persons abroad who left managers or administrators, juridical persons, will run against the state's political subdivisions that act in their proprietary capacity engaged in business, like a normal corporation. Husband and wife, in specific cases provided by the law, such as legal separation, or objections to decisions made by the husband over the administration of common property. Parents and children during the age of majority of the latter, or when the children are in the age of majority and are sane persons not subject to prescription, when such minors do not have parents, guardians, or legal representatives, when such absentee did not leave an administrator and there is no way that the absentee could return, when such person abroad did not leave a manager or administrator and there is no way that the absentee could return to the domicile. It does not run against the state and its political subdivisions acting in their sovereign capacity. Husband and wife for all other cases, even though there be a separation of property agreed upon in the marriage settlements or by judicial decree. Parents and children during minority and or insanity of the latter, guardian and ward during the time of the guardianship. Art 1110. Prescription, acquisitive and extinctive, runs in favor of, or against a married woman, a useless article, honestly. Art 1111. Prescription obtained by a co-proprietor or a co-owner shall benefit the others. CO ownership, how prescription applies. General rule, actual possession of the other parties in the co-ownership is not a requisite for the acquisition to favor the others. There is also no need for ratification of other co-owners in order that a prescription obtained by a party may benefit the others. Exception, when the prescription has no distant relation with the properties owned in common, ratification is needed. Art 1112. Persons with capacity to alienate property may renounce prescription already obtained, but not the right to prescribe in the future. Renunciation of prescription bars the remedy, but does not bar the debt. Usually happens when there is a pending debt and the prescriptive time has elapsed, but the debtor acknowledges the debt and promises to pay it outside of the prescriptive period. The debtor effectively waives the right to the benefits of prescription, one of which is the inability of the creditor to collect the debt that has prescribed. Renunciation enables the creditor to recover the original contract unilateral, does not require the approval of the person benefited by it. Tacit, requires 1. Acknowledgement of a debt and 2. The promise to pay it outside of the period and benefits of prescription. Renunciation not valid when 1. Made in advance, an agreement that obligations arising from a contract shall not be subject to prescription is not binding. 2. Made by representatives, Only persons with capacity to alienate property may renounce the prescription already obtained. Art 1113. All things which are within the commerce of men are susceptible of prescription, unless otherwise provided. Property of the state or any of its subdivisions not patrimonial in character shall not be the object of prescription. Objects of prescription, everything within the commerce of man, and can be appropriated, can be acquired by prescription. Patrimonial property is an exclusion from the properties of public dominion that cannot be acquired by prescription. This interpretation is based on statutory construction to reconcile a conflict between Art 1113 and Art 1108. Not objects of prescription, common things, air, high seas, properties of public dominion and transmissible rights unless otherwise provided. Though within the commerce of man, the following cannot be acquired by prescription. Movables possessed through a crime. Lands registered under the Torrens system. Art 1114. Creditors and all other persons interested in making the prescription effective may avail themselves thereof, notwithstanding the express or tacit renunciation by the debtor or proprietor saving clause for creditors. Even if a person bound by the obligation renounces the prescription, a creditor can still plead the prescription, thereby resisting payment. This plea does not extend to other creditors. Art 1115. The provisions of the present title are understood to be without prejudice to what in this code or in special laws is established with respect to specific cases of prescription in case of a conflict between other civil code provisions. The more specific provision will prevail. In case of conflict between the civil code and other statutes, if there are different prescriptive periods and different types of causes of action, the provisions do not exclude each other from being availed of by the parties. Art 1116. Prescription already running before the effectivity of this code shall be governed by laws previously in force, but if since the time this code took effect the entire period herein required for prescription should elapse, the present code shall be applicable, even though by the former laws a longer period might be required. Present civil code took effect on August 30th, 1950. This article is a transitory provision. 3 rules. 1. If the prescriptive period under the old civil code had already elapsed before the effectivity of the new civil code, the old prescriptive period applies too. If the prescriptive period under the old civil code has not elapsed upon the effectivity of the new civil code, the new civil code will apply if the new civil code provides for a shorter time for the prescription. 3. If the prescriptive period under the old civil code has not elapsed upon the effectivity of the new civil code, the old civil code will apply if the new civil code provides for a longer time for the prescription. Prescription of ownership and other real rights. Art 1117. Acquisitive prescription of dominion and other real rights may be ordinary or extraordinary. Ordinary acquisitive prescription requires possession of things in good faith and with just title for the time fixed by law. Requisites of acquisitive prescription: capacity to acquire by prescription a thing, capable of acquisition by prescription, possession of the thing under certain conditions, lapse of time provided by law. Types: ordinary prescription. See Art 1107c. Art 1113. Good faith and with just title. In the concept of an owner, open, exclusive, and uninterrupted ownership. Movable personal property 4 years. 6. Immovable property 10 years. Extraordinary prescription. See Art 1107. See Art 1113. Bad faith. In the concept of an owner, open, exclusive, and uninterrupted ownership. Movable property 8 years. Immovable property 30 years. Conversion of prescription. What if a possessor's good faith transforms to bad faith? 3 possible solutions, But the most acceptable solution is that the prescription will be extraordinary, but the possession in good faith shall be computed in proportion to the period of extraordinary prescription. This reflects the difference between the two kinds of acquisitive prescription, and puts value to the possession in good faith. Art 1118. Possession has to be in the concept of an owner, public, peaceful and uninterrupted. Art 1119. Acts of possessory character executed in virtue of license or by mere tolerance of the owner shall not be available for the purposes of possession. Possession, to be valid, must be in the concept of an owner. The possessor asserts dominion on the property to the exclusion of all others, must be on concepto d'uno, an adverse possession acts pertaining to the concept of an owner. Ramos vici a continuous possession, payment of real estate taxes not in the concept of an owner, a mere possession with a juridical title unless such title is repudiated, such as being a trustee, usufructuary, lessee, agent. Pledge be that which subsists by mere tolerance or is in virtue of a license, because both of these imply consent on the part of the owner, and thus constitute a recognition by the possessor that somebody else owns the property. See merely transient, in which case the owner is not divested of the title, but cannot exercise ownership in the meantime too. Public, a notorious holding of the property known to the community. 3. Peaceful, for the period of years required by law for the acquisitive prescription to apply, there must be no valid interference from others claiming or asserting their rights to the property. 4. Uninterrupted, see following notes. Art 1120. Possession is interrupted for the purposes of prescription, naturally or civilly. Art 1121. Possession is naturally interrupted when through any cause it should cease for more than 1 year. The old possession is not revived if a new possession should be exercised by the same adverse claimant. Art 1122. If the natural interruption is for only 1 year or less, the time elapsed shall be counted in favor of the prescription. Art 1123. Civil interruption is produced by judicial summons to the possessor. Art 1124. Judicial summons shall be deemed not to have been issued and shall not give rise to interruption. 1. If it should be void for lack of legal solemnities. 2. If the plaintiff should desist from the complaint or should allow the proceedings to lapse. 3. If the possessor should be absolved from the complaint. In all these cases, the period of the interruption shall be counted for the prescription. Art 1125. Any express or tacit recognition which the possessor may make of the owner's right also interrupts possession. Interruptions to prescription once interrupted, all the benefits already accrued in prescription cease. When the prescription runs again, it will be a new one. It is in suspension where past periods may be included in the computation, e.g., suspension because of insanity of a child or during guardianship. Nature of interruption, natural, any cause except civil. Considered interrupted if, period more than 1 year. If the time elapsed is 1 year or less, it is not interrupted. Civil comes in the form of judicial summons to the possessor. Interruption occurs upon receipt of the judicial summons, and not the date of filing of a complaint. It shall be considered an interruption. 1. If the judicial summons is valid. 2. If the plaintiff pursues the complaint to its end. And 3. Upon a final decision against the possessor. It shall not be considered an interruption. 1. If the judicial summons is void. 2. If the plaintiff desists and proceedings elapse. And 3. Upon a final decision absolving the possessor. Express or tacit recognition by possessor of owner's right. One cannot recognize the right of another and at the same time claim adverse possession which can ripen into ownership. Considered interrupted when the possessor him/herself declares or recognizes non-ownership. E.g., where the sale is subject to the owner's right of redemption. Prescription runs only after the expiration of the redemption period. It is not interrupted when a third person declares non-ownership by the possessor. Art 1126. Against a title recorded in the Registry of Property, ordinary prescription of ownership or real rights shall not take place to the prejudice of a third person, except in virtue of another title also recorded. And the time shall begin to run from the recording of the latter general rule. A torrens title recorded in the Registry of Property is never a subject of prescription to the prejudice of a third person. However, the torrens title can be challenged by a claim of laches, if applicable. Exception: when another title is also recorded, prescription will begin to run from the recording of such title. Art 1127. The good faith of the possessor consists in the reasonable belief that the person from whom he received the thing was the owner thereof, and could transmit his ownership. Art 1128. The conditions of good faith required for possession in Articles 526, 527, 528, and 529 of this code are likewise necessary for the determination of good faith in the prescription of ownership and other real rights. Good faith, its essence lies in the honest belief in the validity of one's right, ignorance of a superior claim, and the absence of intention to overreach another. When the possessor is not aware of any flaw that exists in the title or mode of acquisition, mistake upon a doubtful or difficult question of law, always presumed, and the burden of proof lies in one, the party alleging bad faith does not lose its character until the moment when facts show that the possessor is aware of that he or she possesses the thing wrongfully, cannot be invoked in the following examples. Knowingly using a forged document to establish one's possession by acquisitive prescription, or receiving constructive notice of the legal and valid rights of the possession of another during the prescriptive period. Art 1129. For the purposes of prescription, there is just title when the adverse claimant came into possession of the property through one of the modes recognized by law for the acquisition of ownership or other real rights. But the grantor was not the owner or could not transmit any right. Art 1130. The title for prescription must be true and valid. Art 1131. For the purposes of prescription, just title must be proved. It is never presumed. Just title, an act which has for its purpose the transmission of ownership, and which would have actually transferred ownership if the grantor had been the owner. Thus, just title in prescription is understood in the sense of a titulo Colorado, such title where, although there was a mode of transferring ownership, still something is wrong because the grantor is not the owner. Solus VCA. Art 1132. The ownership of movables prescribes through uninterrupted possession for 4 years in good faith. The ownership of personal property also prescribes through uninterrupted possession for 8 years, without need of any other condition. With regard to the right of the owner to recover personal property lost or of which he has been illegally deprived, as well as with respect to movables acquired in a public sale, fair, or market, or from a merchant's store, the provisions of Articles 559 and 1505 of this code shall be observed. Third paragraph. An owner who has lost or has been unlawfully deprived of property can recover the thing from the person in possession of the same. If the possessor of the property lost or unlawfully deprived from its owner acquired the thing at a public sale, reimbursement shall be required. Art 1133. Movables possessed through a crime can never be acquired through prescription by the offender, but prescription will run if the movables are acquired subsequently by another who is not an offender in a crime. Art 1134. Ownership and other real rights over immovable property are acquired by ordinary prescription through possession of 10 years. Art 1135. In case the adverse claimant possesses by mistake an area greater or less than that expressed in his title, prescription shall be based on the possession basis shall always be the possession, regardless of what is indicated in the title. Art 1136. Possession in wartime, when the civil courts are not open, shall not be counted in favor of the adverse claimant. However, if the civil courts are open during wartime, prescription shall be counted. Art 1137. Ownership and other real rights over immovables also prescribed through uninterrupted adverse possession thereof for 30 years, without need of title or of good faith. Art 1138. In the computation of time necessary for prescription, the following rules shall be observed. 1. The present possessor may complete the period necessary for prescription by tacking his possession to that of his grantor or predecessor in interest. 2. It is presumed that the present possessor, who was also the possessor at a previous time, has continued to be in possession during the intervening time, unless there is proof to the contrary. 3. The first day shall be excluded and the last day included. One street rule contemplates a transfer of property from one person to another in a manner provided by law. It is allowed only when there is a privity of contract or relationship between the previous and the present possessors. Second rule. A presumption arises that a person has occupied a property during the intervening time if there are facts showing possession on two different times. However, this presumption can be destroyed by evidence to the contrary. Prescription of actions. Art 1139. Actions prescribed by the mere lapse of time fixed by law. Art 1140. Actions to recover movables shall prescribe 8 years from the time the possession thereof is lost, unless the possessor has acquired the ownership by prescription for a less period, according to Articles 1132, and without prejudice to the provisions of Articles 559, 1505, and 1133. Without prejudice here means that if a possessor has acquired ownership, no action to recover may be filed, even though there may still be several years remaining in the prescribed 8 years. Art 1141. Real actions over immovables prescribe after 30 years. This provision is without prejudice to what is established for the acquisition of ownership and other real rights by prescription. Art 1142. A mortgage action prescribes after 10 years. A mortgage is an accessory contract, constituted to serve a debt, so if the debtor fails to pay the principal obligation, the creditor can foreclose on the mortgage by selling the same in a public sale and using the proceeds to pay off the debt and interest. If there is any deficiency, the creditor can still go against the debtor. The action to file a claim for the deficiency is a mortgage action. Art 1143. The following rights, among others specified elsewhere in this code, are not extinguished by prescription. 1. To demand a right of way, regulated in Article 649. 2. To bring an action to abate a public or private nuisance. Art 1144. The following actions must be brought within 10 years from the time the right of action accrues. 1. Upon a written contract. 2. Upon an obligation created by law. 3. Upon a judgment. The cause of action for a written contract occurs when there is a breach of such contract. Art 1145. The following actions must be commenced within 6 years. 1. Upon an oral contract. 2. Upon a quasi-contract. A quasi-contract is a juridical relation characterized by certain lawful, voluntary and unilateral acts to the end that no one should be unjustly enriched at the expense of the other. Art 1146. The following actions must be instituted within 4 years. 1. Upon an injury to the rights of the plaintiff. 2. Upon a quasi delict. A quasi delict is a contractual relation where whoever by act or omission causes damage to another, there being fault or negligence, is obliged to pay for the damage done. Art 1147. The following actions must be filed within 1 year. 1. For forcible entry and detainer. 2. For defamation. Art 1148. The limitations of action mentioned in Articles 1140 to 1142 and 1144 to 1147 are without prejudice to those specified in other parts of this code. In the Code of Commerce, and in special laws without prejudice means that in proper cases, the prescriptive period in this chapter may be availed of notwithstanding other provisions in other laws. Art 1149. All other actions whose periods are not fixed in this code or in other laws must be brought within 5 years from the time the right of action accrues. Art 1150. The time for prescription for all kinds of actions, when there is no special provision which ordains otherwise, shall be counted from the day they may be brought. Art 1151. The time for the prescription of actions which have for their object the enforcement of obligations to pay principal with interest or annuity runs from the last payment of the annuity or of the interest. Art 1152. The period for prescription of actions to demand the fulfillment of obligation declared by a judgment commences from the time the judgment became final. Art 1153. The period for prescription of actions to demand accounting runs from the day the persons who should render the same cease in their functions. The period for the action arising from the result of the accounting runs from the date when said result was recognized by agreement of the interested parties. General Rule. Art 1150. Exceptions. Art 1151, 1152, and 1153. Art 1154. The period during which the obligee was prevented by a fortuitous event from enforcing his right is not reckoned against him. Art 1155. The prescription of actions is interrupted when they are filed before the court, when there is a written extrajudicial demand by the creditors, and when there is any written acknowledgement of the debt by the debtor. The interruption renews or starts a new period of prescription. It is not a mere suspension,